distinction between correspondence and formal complaints. And then during the break, if you didn't have the opportunity to participate, we were discussing this concept of the trustee visit to schools. Very important issue. By statute, you're required to visit the school or schools under your jurisdiction at least once per year. But you have to watch out. What will happen is as soon as a trustee walks into the school, there will be some sort of notice taken of that, right? And the question for teachers is, in what capacity is this trustee present? Are they present as a parent? You might have a kid who's attending the school. Are they present as a member of the public? Are they present as, and this is probably the scariest option, a member of administration or the board officially evaluating my conduct as a teacher, maybe passing judgment on my teaching techniques or collecting information which may be shared at a subsequent board meeting. What I would suggest as a trustee is if you engage in your annual visit is make sure that your role is clear. There is a visitor policy in place. The visitors are required to sign in. They're required to wear name tags for security purposes. Follow that policy. As individual trustees, you're subject to it. It's part of the manual which you have adopted. So once again, it's like the complaint procedure. It's a policy which exists endorsed by the full board. And as an individual, it's important for you to show honor for and adherence to those policies. It's also going to keep things from getting awkward, right? Because if you reduce uncertainty regarding the nature of your presence in the school, you're going to have teachers who are more at ease. You're going to have interactions which are more pleasant, and you're going to sidestep potential for a violation of the collective bargaining agreement. So one thing we didn't talk about was the fact that in addition to your policies, the collective bargaining agreement sits out there as this alternative or additional source of rights and obligations for all of your employees covered by that bargaining agreement. It's so important, it has its own separate grievance procedure. There can be a grievance filed under the collective bargaining agreement that doesn't fit the form or process of your 1700 formal complaint procedure. It has truly customized terms and conditions. And what I can tell you, having looked at a lot of CBAs, is they vary greatly. There could be provisions in there that you would never dream that would exist, right? Things that are so specific about the use of leave or about the process of gaining seniority, right? These are terms and provisions in a contractual document that you all are bound by that might date from the early 2000s or even earlier, right? So when you take these actions, when you visit a school, when you have a conversation with a teacher, first of all, you have to realize that that person is going to have that emotional response and think that potentially this conversation is occurring as an evaluation of some kind. Number two, if the conversation does not go well, or if you get into what we talked about before, acting individually as a trustee under risky circumstances that are arguably not part of your official functions as a trustee, you're also in a situation where somebody could claim a violation of that collective bargaining agreement. They could say, hey, the collective bargaining agreement describes how, when, and where teacher evaluations are to occur. And it says nothing about individual trustees showing up and evaluating me on a random Tuesday. That sort of complaint, what it's called in the concept of collective bargaining, is an unfair labor practice. It's very likely that the unfair labor practice charge with those facts might prevail. Go ahead.
So board members individually want to come and see what's going on because there's an event taking place, or they just want to be supported. Something bad happens in front of them, they see a teacher behaving badly. You didn't see that. It's like Schultz.
You
see nothing.
You can't ignore it. You can't ignore it for sure. So as a trustee, it's another good opportunity to talk about communication. If you see something as a trustee, or if you hear something as a trustee, it's important for you to communicate that to your superintendent. If a superintendent is not aware of pending facts or circumstances which could lead to a formal complaint, you're going to be unprepared. So first of all, if you see something or hear something, let Ron know. That's number one. Number two, the way in which you address it. If a trustee sees something that needs to be fixed, I think one of the examples we were talking about was, well, if I see an AC unit that needs to be repaired, that's a pretty low pressure situation, right? You can just let Ron know, hey, I saw this. I don't need any follow up. Just wanted to let you know, right? On the other hand, if it's something like actually witnessing teacher misconduct, um, maybe it's something in the community, right? Maybe you go to your local brewery and you see a teacher, and the teacher is loudly discussing a student issue, a confidential student issue, in the hearing of other people, some of whom are not employed by the school district. In that circumstance, maybe you've just observed a violation of FERPA or a violation of your district policy 5223 regarding personal conduct, which requires all of your employees to maintain high standards of integrity, honesty, professionalism, and keep confidential information confidential. That's a situation where, once again, you have to let Ron know. But in terms of substantiating the claim, if you are a trustee but also a witness to the misconduct, it creates issues with your role as a judge. And what I would say is, if you get into that situation, if you have a situation where a trustee is a primary witness to some alleged misconduct by a staff member, find a way to sub them out, right? Certain circumstances as a trustee that you are to recuse yourself from. Specific ones under Montana law, acting as an agent or solicitor for another business, right? No trustee that I'm ever aware of has sold Tupperware as their primary purpose as being a trustee. It hasn't happened, and thank goodness it hasn't happened during my time at the. Well, come on. You all, I think, have the right idea about your service here, which is that it is aimed at developing educational potential. It's important to you on a personal level. It's why you're here in the room. Other circumstances, nepotism, right? Everybody in this community should know that employees in this school district are hired and promoted based on their merit and qualifications, not who they're related to, who's their cousin, so forth, right?
Yeah, I just.
Say more. Say more.
Well, shoot, we've had 5 Germanys or something under one roof, many Rayworks under one roof. So it's a small community, but that doesn't mean people get replaced for themselves and for their wives. That happens. And nothing happens.
And see, the statute is written in such a way that it is not flat out prohibited. What the statute says is that the hire cannot occur for the relation of a trustee. First of all, it doesn't matter if somebody's related to another teacher or your clerk or your superintendent. The statute doesn't talk about that at all. What it talks about is the hire of a relative of a trustee. And it says that hire cannot occur unless a very specific process is followed. You're required to advertise the proposed hire for a period of 2 weeks, 14 days in your local paper. And then when it comes to hiring that individual, the only situation under Montana law where the vote has to be unanimous, and it excludes the trustee who is related. So the trustee who's related sits out to the side, accuses himself. All the remaining trustees have to vote yes on the hire for it to occur. If even a single other trustee votes no, the hire does not occur. So the nepotism statute is really the most detailed example we have of a specific conflict of interest and how the legislature has decided that you all are to address it and deal with it. I think the legislature recognizes that in small communities it can be difficult to find employees who are not related to people who are already present, maybe on your board of trustees. But what they've dictated in that statute is a method by which, even if somebody in the community says it looks weird, you can say, well, according to this statute, there was ample time, much more than the 48-hour notice required for a board meeting, right? So you all can meet for a special meeting with a minimum of 48 hours of notice. This 14-day notice for a potential nepotism hire gives ample opportunity to anybody in the community to come in and say, no, this is messed up. This person is being hired not because they're the best fit for this position, but because of who they're related to, right? And the board has to consider those comments before taking its vote. Yes?
Well, I'm
just curious, so you're just talking with board, with us. Nepotism only applies to us.
Yes, so the statute only applies to the relations of trustees who are hired. Any other employee, teacher, superintendent, clerk,
How
not.
does the district handle nepotism within? I mean, it doesn't apply?
So what I'm talking about is the statute regarding the hire of relations of trustees. Um, any other hire, like let's say you were to hire the cousin of a current teacher, right? The statute wouldn't prohibit that hire because it's not covered, right? In the statute, what you have is this concept of consanguinity, which is blood relation or
I see.
marriage relation.
Like when we are actually hiring somebody for the district.
Yeah.
Yeah, I get that. I get what you're saying now. I'm on something. I'm going elsewhere.
Okay.
Okay, so like when you have nepotism taking place inside of the district, we're not hiring. They're, well, they do. They hire their own without any formal hiring practice. And
They recommend the hiring, is what you're saying, because we actually hire, they don't get to hire. So you're saying they recommend hiring their spouse as a teacher? Like Mr. Germany recommended hiring Mrs. Germany as a teacher.
oh,
Right.
let's use me.
And the board,
Let's just not
Well,
be out of the bush.
No, I was gonna ask.
So how about, I was a fifth grade football coach. I got replaced with the athletic coordinator. He replaced me with him, before I was on board. He replaced me with himself. He replaced my wife with his wife.
So I think the
And
first
this all
thing.
happened.
The first thing that we have to discuss is the powers of the board versus that of the administration. You all are the only authority in this school district with the ability to hire or fire. None of your administrators, nobody else in this school district has the ability to fire anyone or hire anyone. Your administration does have the ability to reassign pursuant to a policy in the 5000 series. But when it comes to hiring and firing, you're the only authority that can do that, which is why the statute says it applies to the relative of a trustee, not the relative of any other employee of the school district. The other thing to be aware of is the appearance of impropriety. So what we've talked about so far with nepotism, with somebody acting as an agent for another business, those issues, those are specific statutes that we can point to, right? The appearance of impropriety can occur in many other situations. And what we suggest is before taking any sort of informal action like recusing yourself, and check with us, because we can give you advice on those circumstances which are not enumerated in the statute, right? But that might still create an appearance of impropriety in your local community, right? We don't want you to be in a position where there are obviously actual conflicts of interest, violations of those statutes or violations of Montana law. We also don't want you to be in a position where anybody can even say there's the appearance of impropriety. So if you have a situation that comes up that you aren't sure as a trustee how to make sure it appears and is actually ethical, reach out to us and we can assist you with that. Go ahead.
So the nepotism thing, so I have a sister-in-law that works in the business office, so any type of decision or discussion, say, raise time or something, I would excuse myself from.
The statute actually doesn't say that. It only
I want to be sure, so.
it only applies to the initial hire, and then it's not exactly a model of clarity. The statute was passed as the result of compromise.
Yeah.
So it's not perfectly clear, but what we believe is that subsequent contracts, let's say you have an employee on that annual contract we were discussing earlier, for each subsequent year of that contract, each time they're renewed to be a custodian, for example, the related trustee should abstain and you should follow the entire nepotism process. On the other hand, if you have somebody with a continuing expectation of employment, a tenured teacher, for example, they automatically get a contract every year. It's not really subject to the board offering that contract. It's automatic as a result of
But
their
if she was to get a promotion within the business office or changing jobs, and so we were approving that or voting on that, I would just recuse
You could, it wouldn't be required by the statute. The only The only circumstance where the statute actually requires it is the nepotism process that I set forth before. And then if there is the appearance of impropriety and you receive legal advice to that effect. But absent a statutory reason or legal advice to the contrary, what the statute on minutes says is that the voting record of each trustee is to be recorded. So we take that to mean that if all of your votes are to be reported, the default approach is that every trustee votes on every issue, as long as it's in your school. You don't have any separation between high school and elementary districts in this school district, right?
No.
Okay, good. The very nasty, like, complicated issue where some trustees vote on elementary and others vote on high school issues, which you do not have to contend with. So the default approach is that every trustee votes on every issue, including the chair. Yes.
So I just want to, again, new to the board here, just want to be clear. So, so we have average Joe's coaching, you know, the baseball team, let's say. And he's been coaching it for a couple of years. The principal wants her husband to coach now. So she says he's going to be the coach. That would come in front of the board, right? It wouldn't just be her decision to put her husband in front of it, right? She would have to make a recommendation to say, you know, my husband John Doe is going to be the new head coach of the baseball team, and you know, average Joe A is out now, and that would have to come in front of us to make that recommendation. So it wouldn't just be based off of her full recommendation. I mean, obviously she's making the recommendation, but she doesn't get the final.
Yeah, no, only the board can hire or
Okay.
fire.
Okay.
That said, if there's a reassignment or transfer, your administration does have the authority to make those in writing. I don't see how that would apply though, because coaches are on written contracts for a specific term, which means that the contract expires automatically without board action, right?
Okay.
Unless you vote to offer a new contract to that individual, their employment is over at the end of the contract. Contract expires, right?
Okay.
Then to fill the position, you would have to hire a new coach, place them on a specific term contract. That would have to come before the board of trustees.
Okay.
to-
And it'd be the same with teachers as well, like a principal, you know, wanted to hire their son or daughter, whatever, because, you know, as Cody brought up, there's been a lot of Germany's teaching in our school, but it's not, you know, it wasn't, you know, Jim's decision, like, that's done. It has to be brought in front of the board, right? Okay.
All approved and
And again,
authorized.
I'm just, you
by
know,
the board
my ignorance
trustees.
here, I'm just trying to learn the system as I go, trying to be the best, you know.
By the way, offered on the condition of successful background check. One of the new laws that we've submitted policy revisions on this from the last session is House Bill 745, which sets a new higher standard for you as a board when you're making those recommendations for hire in ensuring that there is a valid background check on file. And what you're actually obligated to do now under House Bill 745 is ensure that not just employees, but anyone, including the employee of a contractor, a volunteer in your school district, anyone with regular unsupervised access to your students has a valid background check in place before having any sort of contact like that. But this really brings up an interesting topic, which is the hiring process in general. Let me make sure we're doing well here. 7:30 now. How's everybody feeling? Should we continue for now? Anybody tired or feeling like?
No, go for it.
Excellent.
I'm green like.
Let's get into the hiring
Go
process.
back to that comment though, that whole
Yeah.
issue, if, like, you're hiring a teacher, especially renewing a teacher,
Mhm.
those are pretty public events, everybody knows that. But when we have a bunch of coaching situations taking place across the district, that's much less.
If your contracts are written correctly, right? So
Yeah, but as far as, so the board members, in my mind, board members will have, if they're hiring a teacher, it's a brand new person, whatever. But if it's, you know, a non-tenured teacher and they're making these decisions, I think that becomes hard for them to know anything about maybe what's taking place in fifth grade basketball or something like that.
sure.
And at that point, what would you say for a solution on that?
Well, it depends on your model. So there are districts where there's a low enough volume of hires where you can utilize a committee, hiring committee. That committee is made up of less than a quorum of the board of trustees. They can actually sit in on the interview of individuals who are applying for employment in your school district, responding to an advertisement for a teaching position. That committee then basically acts as the administrator. They make a recommendation to the full board. We believe you should hire this person, and here's why. Their experience, their qualifications. Another important statute that sits out there, in addition to the nepotism statute, the statute states that when you are making your decision to hire an individual, you make that decision based on two things and two things only: their experience and their qualifications. Doesn't matter what church they go to, doesn't matter who they're friends with. You as a board of trustees, as a public employer, have to make your decision based on only those two things. What you have to avoid are any of the protected classes enumerated in that human rights statute, which we talked about before: age, gender, all of the protected classes that you've heard before, right? And lots of people thought that the hiring process was pretty safe for the most part. I would say that we've seen more and more claims regarding discrimination in the hiring process throughout my time at the association. It starts with the advertisement, right? The publication of a request for the position to open, a job description, a document that sets forth the essential functions of the job, so that people can know whether they fit, right? This is where you set forth requirements for certification, right? A valid teaching certificate, absolutely a requirement for your teaching positions. Maybe physical requirements, if this is a position that's going to be lifting a certain poundage on a day-to-day basis, chasing after kids. Then you receive applicants based on that job description, and you can point to that job description as the basis for your decision later, right? So say that person interviews for the position and they don't resonate with the hiring committee and you decide they aren't the best fit. Later on, when somebody else is hired and there are hurt feelings, they can come back and say, no, well, I feel like I wasn't hired for that position because of my gender. And once again, it's a situation where the burden shifts to the employer to describe your hiring process in a way that lets the people in your community and this person who's challenging you know that you make your decision based on merit and qualifications and nothing else. Then once the interview occurs, you get to this point where you're looking at potentially offering them a position. Very important moment from a contracting point of view, right? Every contract requires offer, acceptance, consideration, money changing payments, basically. And this board meeting is where the board votes to make that offer. An offer creates the power of acceptance in the person that you make the offer to, right? So they can say, yes, I accept your offer, or no, I don't, I decline your offer, or counter, right? They could say, I'd like to take the position, but I want 10 grand more per year for this teaching position. Counter offer basically functions as a new offer, right? So it creates a new offer of acceptance. In the board, you can decide whether to accept that, negotiate further, move on. It's important under House Bill 745 that you make sure that your hiring process respects and dictates that every new hire will have a background check in place before contacting students. 745 really goes much further than the Volunteers for Children's Act, which was the main statutory authority for our model policy for years and years. And what you have now is a situation where you're expected as a board of trustees to ensure appropriate supervision for students at all times. There were some gray areas in the past. We handle a huge number of school bus cases, right? It's some sort of activity. There's a bus transporting students to the activity, and sometimes the sole supervisor for that activity is the driver. Not sufficient anymore. You can't really have trips or student travel that occur with only a single supervisor. You also have to watch out for situations where sleeping quarters are being shared. You have to ensure appropriate supervision at all times. And House Bill 745 really calls into the light a lot of differing practices between school districts. What I would say is if you have a set way that you've been doing things, a structure for supervision, email it over to our department, make sure it complies with 745, because this new statute, 745, creates a lot of potential liability for districts that don't pay attention. But it sounds like you're on the right track in that regard. You have a question?
I do. I should be clear on this, but I'm not. Is the job open for 14 days for anything, whether it be a teacher or a janitor or a coach or a paraprofessional, or is it open for 14 days?
Montana law has no specific requirement regarding the posting of a position of employment. You could potentially walk out onto the street and say, hey, you look like a good fit.
That's what I wanted.
Come in, interview for this position, make a recommendation to the board, and then that person is hired. What we would suggest is that you have a little more formality. When you don't have an advertisement, when you don't have a job description that is provided to your applicants, it creates room for them to make allegations of discrimination against you in the hiring process. Sight unseen, right? You don't know this person from Adam. You might have spoken to them once or twice. Maybe they don't get an interview, right? And they have this legal claim against the district. It really protects you when you make sure that they fill out an application, they view a job description, they submit materials addressed to that job description. If you start things less formally or without those first steps, you can get into issues. Contrast that with your teachers. You might have a provision in your collective bargaining agreement that says whenever there's an opening on your teaching staff, maybe there's a day requirement, 14 days are to elapse while the position is posted, at which point the administration will determine who receives it.
Lots of information. Yeah.
Totally different for teachers with a CBA, because that CBA is going to set forth specific requirements. If you fail to adhere to those requirements, it's a unilateral changing the conditions of employment or an unfair labor practice.
On the other hand, what if you invite, just for example, someone back 3 times for an interview and still do not hire them?
That's called torture.
Technically,
It was torture.
Everyone.
technically, there's no position of employment created until there has been an offer. So from an employment standpoint, your level of exposure or your level of liability increases as your connection to the employee increases. When they're just an applicant, your liability is capped at making sure that you have a hiring process that is non-discriminatory. You provide that non-discrimination notice on the application of employment. You have a job description, which helps attenuate ADA claims of disability. And you abide by that process for every single hire that occurs. Once the offer is made and accepted, you have an employee. Employees are totally different. You have a whole host of obligations to them, all the way from the ADA with reasonable accommodations, through the Family Medical Leave Act, which requires unpaid leave for qualifying events in people's lives, the birth of a child, severe injuries, and so forth. And then you have contractual obligations to those people. So your employees have a very close, very heavy, and potentially very valuable relationship, a due process constitutional property right in employment with your school district. That right is of different sizes depending on which category of employee we're talking about. But as soon as they're an employee, it exists. It's there. It has tangible value. Should we go through the ADA and talk about employment qualifications? Yes.
You said job description, so I've been asking for job descriptions for a long time. Our policy says there should be job descriptions.
Mm-hmm.
I don't have them.
Hey, this is another place where your dues are going to pay benefits. We maintain a bank of model job descriptions for every position in a public school that we update on a regular basis, as well as those specific term contracts that we were talking about before. If you have old paper, if you have specific term contracts that say, oh, this person is employed for the following athletic season, or from August of 2025 to July, or from August 25 till the end of August in 2026. Those are not contracts for a specific term. There have been updates to those forms as a result of new legislation over the years. So pull new job descriptions from our website, mtsba.org/MELR, pull updated contracts and forms from us. You don't have to reinvent the wheel. We have those resources for you updated on at least a yearly basis, as well as anything else that you're curious about. So in addition to those forms and the job descriptions, if you have questions about school construction or questions about public comment, if you absorb information better, we have written materials for you in the articles section. So we have annotated guides about the process for convening a board meeting. We have a detailed guide for public comment. All of those topics are in written format. Once again, if you learn best in a presentation format, like what we're doing today, if you go to mtsba.org and log in, you can contact Wendy Brendan if you have issues logging in. There's a tab called Learn and Lead, which has recordings of all of our monthly trainings. We have at least a monthly training on a subject of interest to school board trustees. So without paying for anything, you can go and pull those recordings, watch them at any time that works for you.
So the job descriptions from MTSBA, I can print them off.
Yeah.
You can just give them to them.
Yeah. And
That constitutes a job description. You don't need a MOA or anything.
there's a watermark on the bottom, which just is like our copyright mark. You can tear that off, insert your district name, and you're off to the races.
Okay, because our policy says it has to be specific and delineate is the word it uses, all the duties.
Mm-hmm.
Well, the MTSBA ones do not.
Oh, they do. They have the list of duties right there on the first page. And
They do, right, you're absolutely right, but I mean, okay, then whose job is it to see those duties are being followed as stated?
Okay.
You know what I mean?
Yeah, the evaluation process. This is a hugely important part of being an effective administrator and part of your duties. I was just going to talk about this, so this is perfect. Your administration has at least an annual duty to perform true evaluations. Those are not evaluations that are rubber stamped. They're like, excellent, 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 right? These are evaluations that truthfully tell an employee where they stand, how their performance is stacking up against the requirements of the position, specifically the requirements that are enumerated in the job description, and giving them tips for how to improve their performance. That evaluation occurs in writing. It is subsequently filed in that employee's personnel file, and that employee has a corresponding right to file a written response to that evaluation. Let's say they disagree with a particular mark, or they believe that they were not given a sufficient opportunity to improve an element of their work, maybe their presentation skills, right? So maybe they got not the number of comments that they wanted regarding that. They can file that written response. It goes in the personnel file. If you get into a situation where evaluations are not conducted on a regular basis and there's personnel action, the employee almost always brings that up in the lawsuit or in the HRD case. A lack or a failure to evaluate is a serious problem when you're talking about substantiating a case for poor job performance. And poor job performance is your main defense to these legal claims that can come against you. So in addition to making sure that that happens as a board, and I'm quoting directly from Board Policy 1511, which is your code of ethics for school board members. A specific item on this list is support the employment of those persons best qualified to serve as school staff and insist on regular and impartial evaluation of staff. So this is not aspirational. This is not optional. You must make sure that evaluations are conducted in the school district. Going through the rest of this list, this is a list that I think we've talked about in detail pretty well so far tonight, but it never hurts to go through. Number one, attend all regularly scheduled board meetings as possible. Become informed concerning the issues to be considered at those meetings. When we talked about reviewing the agendas, making sure there are no surprises, reading the agenda, preparing yourself for the board meeting is essential, because if you don't read those materials, you're in a situation where everything is a surprise, right? Don't get into that situation. Don't allow people to spring anything on you. Prepare for your board meetings. Recognize that I should endeavor to make policy decisions only after full discussion at public board meetings. That's what we were talking about with the open meeting laws. You are not only complying with open meeting laws because you have to, you are using the open meeting laws as a tool of engagement with your local community and a way to show them that you are transparent as a board of trustees and you honor their rights in that regard. Next, make all decisions based on available facts and my independent judgment and refuse to surrender that judgment to individuals or special interest groups. You are a representative of, not a representative for. You are not just a puppet sitting on this board directed by the people around you. You use your experience, your qualifications, your unique viewpoint as a person to make your decision and vote your conscience. The next item, encourage the free expression of opinion by all board members and seek systematic communications between the board, students, staff, and all elements of the community. When I read that one, it makes me laugh because I think of hanging out with my family. And we don't always encourage the free expression of opinion, right? If you think about your personal life, there are people that you maybe don't want to express their true opinions, right? You know things are going to go better if they don't, right? But as a trustee, you have to switch into this alternative mode where, you know, no matter whether you agree with someone's viewpoint, at the very least, you're a champion of the process and you recognize their right to speak at board meetings and to be heard. It's a fundamental change and not something I honor in my personal life all the time. I mean, I'll just tell you there. But as a trustee, there's this higher expectation of you because of your status. Next, work with other board members to establish effective board policies and delegate authority for administration to the superintendent. It says it right there. You guys set board policy, you discuss and decide the direction of the district from this high level, and then your superintendent hears that and goes out and executes.
Question.
Yes.
This is, now you're getting into more what I would like to talk about. Steer had questions with anyway. But so we point the direction, the board points the direction, the superintendent steers the vote.
Mhm.
Right? I had this conversation with Deborah. We hire an athletic director, the superintendent tells them to stay out of athletics.
So here's what we can do tonight. I think we can talk about how to communicate about issues like this. Since this is a public board meeting, if one of you were to ask me a legal question tonight about how to deal with a specific issue that's going on, rather than a communication style or a policy, we no longer have the attorney-client privilege, right? There's what's called inadvertent waiver of the attorney-client privilege. If I loudly start discussing a student issue with your superintendent in the hallway where other people can hear, we have arguably waived the attorney-client privilege. Questions about specific ongoing issues or forensics about things that have happened in the past are not what we're here for tonight. What I would suggest is if you want to discuss your communication style, ways in which you believe your superintendent should be communicating with you, whether those meet your expectations or not, do so. But let's hold off on discussing specific issues because, I mean, frankly, I'm concerned we could waive the attorney-client privilege in this setting. And it's also not a conversation about how you're going to fix this in the future. So if you could take what you're talking about and describe a way in the future that your administration could communicate with you about that in a way that would please you or operate in a better way for you, go ahead. What do you guys need that you're not getting right now in terms of communication style?
They're doing. Let's talk about Scott's $10,000.
It was not hidden.
Yes, it was him.
I don't think it-
The board, did the board all know about it?
Yes. That's everybody.
Did you know about it?
So say against that, the $10,000.
The $10,000 that Scott got.
Oh, Scott, I'm sorry, that's hard to hear. Yes, I did know. Yep, Ron did talk to me about that.
This
And
deceit.
I gave my opinion for him.
I think this is getting to what he said about like.
Specific issues, right?
Yeah.
So if we're talking about
Not
a
to bring
way
it up in this setting too, because
waiving the
How do we ever
attorney-client privilege.
accomplish anything?
What's that?
How do we ever accomplish anything?
I think what we have to talk about is the communication methods that you have so far, right? It sounds like there's at least a weekly report that goes out, right? What else?
Ron's door is always open.
Yeah,
You can always go in and ask questions or phone calls or anything like
And
that.
how is the weekly report circulated? Is it an email? Email? Okay. And you're all receiving those emails. You're looking at them. Are you pleased with the detail of those emails?
No,
Okay.
if I'm not, I ask questions.
Okay.
I ask questions.
What level of detail, I guess, are you looking for?
Where's the record of it?
Of the emails?
No. Oh, Scott, I've asked for the record now for a month.
So-
I can't get a record.
So what? Let's divide what we're talking about. It sounds like you're discussing a particular issue that happened in the past.
Yeah.
And what I think we should focus on tonight, what we can focus on during a public board meeting, is a way to facilitate a discussion about communication styles, what needs to be fixed in the future, right? We can also talk in a broad sense about public records, what constitutes a public record, what information is available to the public, if that would help address your question. But in terms of the emails, is that working for everybody? How do all the trustees feel about
I'm
that?
curious to know on that. That's a good question.
I look forward to them. I like to know what happened.
I think I enjoy them because I feel like it's a weekly update. I mean, we're fairly busy, and so it's a weekly update into our schools.
Yeah.
So.
I just got my email, so I'm new to this, so.
Awesome.
Yeah.
So far,
I
so, I mean.
probably come in once a week
Yeah, I'm very new to this, and
and just gather information.
I just been trying to get to know every.
So it sounds to me like for the most part, the email is working. Next, I think we have to talk about open records. So as a part of transparency, as a part of making sure that everybody has the right ability to participate in board meetings, and frankly, as a public employer funded with taxpayer dollars, you are subject to the open records request law in the state of Montana. You have a policy which describes the steps that administration will take in complying with public records requests. Generally speaking, there are two types of public records requests. The first is one that requests existing information, warrants, expenditures of money, correspondence that is not regarding a confidential issue. Those things are pre-made, right? You can download them, attach them to an email, fulfill that public record request very quickly. The other type of record request is something that requires compilation or summarization of large amounts of data, right? Those are situations where you have the ability to charge staff time for fulfilling that request. But for the most part, when you receive a records request, let's say somebody wants to see all your employment contracts for coaches, right? Employment contracts, a staff member's rate of pay, their employment status with a public employer, that's all public information. So that stuff can be given out. Where you have to watch out is where you might potentially disclose confidential information, like withholdings, right? If somebody's asking to see paychecks, for example, there can be information included on a paycheck regarding a person's withholdings, regarding their elections for a certain health plan. That information is not public, right? So you have to watch out in fulfilling those public records requests, how that happens. But you have a policy which describes how it occurs. The request is made in writing. Your administration is responsible for responding to it. You had a question over here?
Yeah, so as a trustee, we can request
Anyone?
any employee of the school district's compensation package or whatever it is. I mean,
Uh,
so if I want to know how much the shop teacher's making,
Yes.
it's a. I
It has been
It's
put-
a public record.
It's been posted in the newspaper.
It's a public record.
And we do get is it weekly warrant report, from what the expenditures are?
Yeah, I mean, I've seen that in Tracy, right?
Yeah.
Yeah.
You get those too, that
Yeah, yeah.
explain
No,
where things go.
Yeah, I've seen that too. So
So-
I'm just curious about it, like, there's a specific, like, I want to know, how much employee A is making for doing.
And not just you, anybody.
Okay, so not just as a trustee,
Any state employee, like past that, like anybody can see how much my wife makes for the period of time that she worked at the Department of Commerce in Helena. Any state employee there.
Well, yeah, you just Google that, and it shows you exactly how much everyone makes, yeah.
Yeah,
I looked at state law.
But every school district is required to have a policy for fulfilling public records requests and provide that policy on its website, which you guys do. I think we should go through the rest of the code of conduct unless there's other comments at this point or other ideas for reforming the communication style. So hearing none, I think we should continue.
How would we talk about things that I want to talk about then? Fair question, you know what I mean? I won't say anything specific. How do we as a board then, I can't talk to him outside of this board meeting, I can't do anything because I will lock myself up pretty much. How do we talk as a board, you know, on,
Right now, we're posted, it's public.
but we can't talk about what I just want to talk. See what I mean? Like,
So-
when do we get?
So here's the thing, for
How does it
forensic
work?
issues, for actual legal issues, right now, we're noticed for board training. Right? That's all the agenda says. And that's another piece of the open meeting law. Every agenda that you post has to accurately and completely summarize all items that will be under discussion at the board meeting. So if we transgress the concept of training in a general sense, or reviewing your policies in a general sense, we're in risk of violating the open meeting laws right now. So that's the first thing, right? In terms of addressing past issues or forensically addressing issues that you believe may have violated district policy, what I would suggest is you have an open dialogue with your superintendent. On the other hand, if there are options or ideas for improving things in the future, now is your moment. This is what I wanted to talk about during the training tonight. I know that this board has been having issues, and I would like to try to help fix that. I feel like if we can have a conversation tonight that improves or strengthens your communication process, we will have had success. So the weekly report, the open door policy, what else can your administration do? This is the time to say it if you're thinking it. And if it's not supported by the board, it's not supported by the board. But this is one of your only opportunities to stop talking about individual issues as they arise, which is whack-a-mole, right? You deal with an issue, it's passed, you don't talk about it, right? These board trainings are one of your only opportunities to talk about how you will make decisions, how you will communicate with each other. And what we have to start with is that stuff from the Code of Ethics, which is that first of all, you respect each other, you respect differing viewpoints, you recognize that there are going to be differing opinions about the past, about the future, but how you deal with those and how you have the conversation is what matters. So if anybody feels like the conversation needs to be changed, like you need to communicate in a different way, now is your moment. I'll shut up. You can talk about how you want to communicate in the future all you want right now.
I feel like we go backwards, we want to have discussions about things we can't, we're not going to change it. It happened in the past, let it be in the past. Moving forward, we can learn from what was good or what we failed at. That's really been on the board when some of the conversations are coming up about things. And there's really no value. You keep digging up the skeletons from the grave. Moving forward, we can move forward with, hey, that didn't work very well. This is what I got from that.
I agree with you 100%.
And
I also think perception is when someone is on the outside of the board and looking in, it's entirely different than being on the board. Perception is something we have to be very careful with. And like you said, Tony, continually bringing things up, not that we have continually. I understand you're upset now, Corey. I didn't.
Totally.
And I don't want that to happen.
No,
I don't think that's a good way for the board to operate. I think it's fine to have discussion, but I don't think anger will settle anything.
I'm not angry.
So I'm
It's
not
fine.
saying, Corey, I'm not saying you are angry.
No.
I'm saying anger doesn't settle anything. any more than perception does. So I think we have to be real careful on comments that are made. And I think by going to Ron and asking questions, what other way?
I'll give you a perfect example. You had asked if I knew about that and, the situation with some monies, and I did. And Ron brought it up to me, and you're gonna be real surprised. I didn't agree, and I had some valid reasons. I was concerned about others. If we did it for one, we.
I
care, we
said
do
the
it.
same thing, Tony.
So I mean, but at the end of the day,
Yes,
when the decision was made, I supported that decision.
yes.
I've been on a lot of boards, and I know how they work with me, and just because I'm against it doesn't mean at the end of the day, when the decision is made, I'm gonna support that. I had my opportunity to do it, and I felt that Ron gave me that opportunity, called me specifically, and, we had a conversation. It was a great conversation. And at the end, the decision was made.
And again, when I joined this board and I told everyone this, the interviews and the forum and everything like that, I said, I have my personal beliefs in a lot of things, but I wanted to come to this board with an open mind and no agenda. That's what I wanted to do. Like, that was important to me, to listen, and even if I disagreed, to try to understand why BG or Elida or Tony or Cody felt those ways about those things. And even if I didn't 100% understand or get it at the end of the day, or agree even, even if I vote differently, to put my opinion out there, that was important. But I wanted to, not come in here with such a closed mind that I couldn't hear what everyone else was saying. Because at the end of the day, I really think for not, the school or whatever work the best, it falls in the middle. Like, there's got to be some compromise. Otherwise, we're just, on this way, and just beating our heads against the wall, and no one's going to be happy.
And I think we have to remember that the whole reason we're here is for kids. And we're here, the very first thing we're here for is to make sure they get the best education possible. And I've said this a million times, and being an old school teacher, I will say it a million more. We spend hours on athletics especially. We spend minutes on curriculum. In some ways, that's very good that we're not getting into curriculum. I know many schools are having those problems, and I'm sorry I even said it, but I think what you said is so valuable. I really do. And I think all of us feel that way. I hope none of us have come with an agenda. Those of us that have been on for a long time and those of us that are new. We're all learning to work with each other. This is a new board. It really is.
And one of the things in my first training, and it was a hard lesson to kind of learn because it's not always easy for me, but you have to learn to trust your administration and to trust their decisions. And as a board member, we can't micromanage everything. And I appreciated your funnel example of we shouldn't know about anything until it gets to the very bottom, to the extreme, because that's a hard thing. Because it is a small community, we do have people come to us and talk to us, and it's hard to trust decisions. But that was, I think Chris Goss probably did our first training, or my first training, and that's one of the things that he said. And it's just like, you have to kind of learn to trust your administration. And it's good to go in and ask questions and get reasons, but you don't always have to agree. Like Tony shared his thoughts and his things with Ron, and a different decision was made, and he accepts that. And it's hard. It's hard to let go of sometimes, but
Ron, I know you want to speak. You raised your hand several times. I want to say one thing before you do, which is that this is the type of conversation that creates good board members.
It's about time.
Every board member who has ever started on a board in Montana has had some sort of reason, right? During COVID times, the reason was masks, right? There were a lot of people angry in the state about what was going on during the pandemic. And at the time, the consensus around many trustees in the state was these are worthless trustees. These are people who, as soon as the issue is resolved, they're going to go off. They're going to have nothing good to say about education. What actually happened was very different. As soon as you have people interested for an idea that gets them excited, that creates intrigue for them, they realize that there's other things going on in the school district. They realize their true discretion as a board member, and they become quality board members as a result of coming onto a board in a circumstance which no one would anticipate, right? Maybe it's a student issue. Maybe they had some sort of really bad student disciplinary issue, and they ran on the platform of I am going to target this particular school employee, and that's going to be it for them. That's going to be my service as a trustee. Many trustees end up finding more along the way, and I think that's exactly what you're doing. Ron, you wanted to speak, so
Yeah,
please
I
go
know,
ahead.
one of the things I was in the hiring process. So, when I think in terms of what I know about, as far as, if I'm gonna sit on an interviews of teachers and coaches and all that kind of stuff, but what I see is one of the bigger issues, and I'm gonna say, I think we do a pretty good job of hiring teachers and saying, teacher can't stay as well. And that happens almost every year, we non-renew someone. And so I think that's healthy. But what I don't know, and I don't think board members know either, and I guess the question is do we feel like we're not getting a good situation on coaches? And unfortunately, that is a big issue in our community as far as, how do we make that decision? Some sports, everybody gets to see it. But again, when we're talking like this, sixth grade, sometimes I see these people's names come across and they know who they are. And I'm assuming making a good decision. I don't know what we could do to change that, make sure that something doesn't happen when, there's a recommendation that comes through and really wasn't very thoughtful.
I think the first thing you have to address with coaching hires specifically is that the default approach is they're on automatically terminating contracts.
Yep.
That doesn't mean your administration is checking out. It's actually our fault. So we wrote the automatically terminating contracts. If you want a different structure, you can make your own structure. A specific term contract can be for whatever term you want. If you wanted to convert a coaching contract to a 2-year contract, you could. You wanted to do a 6-month contract, you could. It's 1 year because that's the way we drafted it to take advantage of the law. And if you feel like there's a lack of thoughtfulness, or if you want to reevaluate how that hiring process occurs, do so. We'll help you.
Perception, you hit it right on the head. You can have 20 kids on a team, and that means you got 20 parents with a different idea about the coach. It's just how it is. And I've asked this in our few board meetings, if the recommendation, who it came from. Remember, I've asked Scott when there was a recommendation for a coach, who's the principal at high school, and I've asked Mrs. Kidwell, who made the recommendation, and then I trust the recommendation. If I don't trust them or trust Ron, then I gotta get rid of it. I mean, it's a brutal, cruel thing, but if we can't, and I do trust him, and I have the utmost respect for him, but if it comes to the point that I don't, and his decisions are so bad continuously,
Get rid of me.
we need, I tell all the people who work for me that every time.
There's a reason why you get leeway with teachers and you also get leeway with superintendents.
Yeah.
The maximum term of a superintendent contract in the state of Montana is 3 years. So if something's not working for you, fix it for money or for a little bit of effort. If you need to change your communication styles, work things out, do it. Otherwise, you will pay money to fix it down the road.
I have a kind of a personal question here, just as a board member, well, it might not even matter next year, it's not only 1 year if I don't re-elected, but, I haven't done two.
It's kind of a death sentence, actually.
I know, if I'm not throwing my name in the ring there for 5th, 6th grade, football coach next year, as a board member, how does that work? Is my,
Can't receive paying them.
So you don't think that- you can't be a coach as a board member, correct?
No, you can't be employed, no.
You can volunteer.
So I can volunteer, but I just can't, okay, that was it.
You aren't supposed to volunteer either.
Fortunately, this,
Not
this
supposed
is
to
about
volunteer.
all you're gonna get paid.
This,
Really, so.
so this is one of the parts of Montana law that I will tell you about. I know that there are a large number of people across the state who are not taking this recommendation, who are actually doing this. But the doctrine of incompatible offices in Montana, which was set down in the 80s by then Attorney General Masaryk, was that no position can exist that has revisory control over itself. It's not about compensation. It's not about whether you're paid by the school district or not. It's a question of who supervises you. And the answer with both regard to your employees and your volunteers is your superintendent. As a trustee, you are in a revisory role over your superintendent. So
I'm the voice of the law. So
just don't
don't
tell me about it if you are going to do it.
No, it's, now it's all games. All the sporting events.
There's an exception for
No,
officiants.
no, there's not.
There is.
You can't, you gotta get me out.
I know, I just felt like I got.
I totally misconceived what the purpose of that was.
Doing the football coach thing was being forced on me for that extra. I just got a jump free card. I can't do it on the board.
If you want more details about that, reach out to me. Otherwise, don't tell me what you're doing. I think we should get through the rest of this list. Let's see here.
And my wife probably.
This one is directly about what we're talking about right now. Communicate to the superintendent expression of public reaction to board policies, school programs, or staff. I think the worst thing any of you could do as trustees is fail to communicate the public perception of the actions of this school district to your colleagues and to your superintendent. The worst thing you can do is freeze up and fail to communicate. You have to communicate that and make sure that your community, you're using the people who talk to you to make sure there's clear feedback with this school district.
This is the perception.
Yeah, exactly. This is the conversation right here. Inform myself about current educational issues by individual study. We talked about all the opportunities you have, at least monthly opportunities to interact with your colleagues from around the state, to learn about the legislative process, learn about the bills that MTSBA has taken positions on, attend our conferences in person or by Zoom, support the avoid being placed in a conflict of interest. We talked about reaching out to us, the statutes that apply, avoid compromising the board or administration by inappropriate individual actions or comments, and respect the confidentiality of information that is privileged. And then finally, remember always that my first and greatest concern must be the educational welfare of students attending public schools.
Go back to the next to the last, please. Would you read that again?
Avoid compromising the board or administration by inappropriate individual action or comments, and respect the confidentiality of information that is privileged under applicable law. So remember, this one is what I was talking about before. If you go out and you take actions, have conversations that are not in your official role as a trustee, that are not authorized or delegated by the full board, you're on your own. The official immunity statute doesn't apply in those circumstances, as well as violating the code in your policy. You're also taking on substantial risk yourself. So don't do it. If you have a question about what falls within your official duties, let us know. We can clarify it for you. In Montana, a board of trustees does not have the ability to unseat one of its own. That's actually reserved to the county commissioners. Once again, hasn't happened in my time at the association, not even once.
County commissioners can.
They can. The sole authority that you have, which I would describe as a last resort, is a public admonition of one of your members who continues to engage in individual actions, basically disclaiming those actions. Their actions and comments do not reflect the authority or will of the Board of Trustees. Once again, 3 of those in my whole time at the association. And there are like 36,000 trustees across the state. So for the most part, you guys provide consistent community-informed public service, and we're glad to help you do it. And if you have any issues, if you have problems communicating, or if you just have a legal question, we're here to help. For instance, I always like to point this out. My salary does not go up or down depending on how much trouble you get into. You talk to somebody else with a legal license in this state, there's a big juicy case in your school district, they could buy a boat. They could get a vacation. If there is a mess up in your school district that leads to an award of attorney's fees, it could be a second home for them. My salary remains the same, and that's true of all of your legal counsel. Yeah, exactly. There will be no benefit to me. I will give you the same advice that I would give to any other trustee. So, with that, folks, we are coming up on 8:30, which will be 3 hours since we started.
It went fast.
It did. It did. And I tell you what, it went a lot faster than Somers yesterday, given they were recently bereaved and barely had quorum. But this has been very stimulating for me. And as I said before, this is not your only opportunity. You have access to your legal team, gloves are off, asking any question you want at all times by sending a legal email to legal@mtsba.org. That way we can make sure the question is answered under the attorney-client privilege.
And you LE and it pops up.
Yeah. Perfect.
I have a couple of clarification questions, if you don't mind.
Yeah, go ahead.
At one point in the training, you had said, you talked about trustees going in on an evaluation thing. I was under the impression that you can't do that. Like, I couldn't go in and evaluate a teacher.
No.
Okay. Or a coach or anything.
No,
I'm
no,
not allowed to.
The point of the comments on that is that you are required statutorily to visit the school that you're a trustee at. But when you do, you have to abide by the visitor process. And it's important, this is not a requirement of the law, but I would say on a social basis, it's important that the people around you know this is not an evaluative visit.
Okay, so you're just saying reference.
You give a heads up to your administration, hey, I'm doing my yearly visit, I'm going to be in the building, I'm going to sign in, I'm going to wear a name tag, you let them know so they can warn the teachers. Otherwise, you get into these weird situations where it's like, oh, there's a trustee in the building.
I don't think Cathal will know that.
Yeah.
That's something I really wanted to do, and not like once a year. Is I wanted to be in, both schools on a regular basis.
Yeah.
This year, I have a kid in the 4th and 2nd grade, and my daughter graduated a couple years ago. But so maybe is there too much being in the building? I mean, I don't want to I would love to be in there, like reading to the kids at times, or just like walking around and meeting and talking with the teachers, so they get comfortable. Again, I grew up here.
Their exact words are they feel support. And they like that more than anything else.
Yeah.
And what the statute said is
When you can get dad into a classroom to go in and listen to children read or anything, it's amazing and it's well.
And that's kind of what I want to do. Is
Because
just
it
to
was
be,
probably a dozen times last year.
yeah,
Thank you for your support.
that's awesome. And
At least.
I just didn't want to go like these first 2 days because I know it's the beginning of the season, beginning of the year, everyone's kind of crazy and things can move and groove. But next year I already have talked to Nick Raverts. I want to meet him about something, and I've talked to a couple teachers where I plan on getting in both the elementary and the high school middle high school next week for a couple hours. This starts going to my slow season with my business, so I actually have some time in the afternoons to.
Okay, I just have one other
Nope, you ran out of
thing.
Go ahead.
At one point, you had referenced the nepotism hiring process, so I'm circling us back around there.
Mhm.
We do have 2 board members have coaches, Rob, he's not here, and Cody's wives are both coaches.
Mhm.
Our coaching contracts are a yearly contract.
Mhm.
And you said something about posting it for 2 weeks prior. Do they have to do that on a yearly basis?
You do, because those are automatically expiring contracts. So the board must act to offer a subsequent contract. The nepotism process applies. By the way, if you want to view that process, it's in your own board policy. 1512 is the reference, and it talks about that procedure as well as other ethical requirements.
I just don't want us to get in trouble. I mean, they do a great job, and I'm not saying, she coaches volleyball. Yeah.
Yeah.
And I just want to make sure that we're following that. So does it have to, the job opening doesn't have to be posted.
The
Or-
intention to hire the relative of a trustee must be published for a period of 14 days. I believe we actually have a model notice for that purpose, so you can go to mtsba.org/MELR, pull the model notice for a nepotism hire, and just fill in the blank.
So it's to be posted in the paper,
Correct.
essentially,
Correct.
not like posted opening or anything, it's not. Because typically, like,
What the statute says is in the local paper of the greatest circulation. So I don't know if you have multiple papers here.
Well, we got lots of papers.
When I was in school, it was a regular event,
Yeah,
because likelihood of, well, everybody's hired.
it happens all the time, folks. It's still a small state. And tell you what, it's personally meaningful to me because our executive director, Lance Melton, happens to be my uncle. And whenever anyone is trying to attack his decisions or my decisions, it invariably comes up. I believe I do have value other than being his nephew, but that's determined at some point in the future.
I'll let you know, it's who you know.
At any rate, if you have a question, everybody has these issues. It's nothing to be embarrassed about. There is help for you in Helena, and we care very much about your involvement with us, the dues that you pay us. I also think that trustees are singular people. You guys make incredible friends, and the acquaintances that I've made, the friends that I've made among all of you and your colleagues, I want to make more. I want to know you better. And the only way we can do that is if you have juicy legal questions for them. So reach out. Don't
so
be
we're okay as individual trustees to reach out and ask
Yes,
the questions?
yes.
when
There will be
decisions are
moments, because we represent the board as a whole, there will be moments where we will link in your superintendent. There are issues that need to be, addressed by someone else, especially the board chair, for instance. But for the most part, yes, we can answer brief questions on a one-on-one basis.
procedure. or
Yeah,
something
yeah,
like that.
and help you with communication issues, right? Maybe there's something that Ron wants to tell you about that's privileged or confidential. He can reach out to us, say, give me legal advice on this issue, and also please let the board know. And you get an email that says attorney-client privileged communication at the top. It's marked confidential. I can tell you anything you need to know.
Didn't know that, that's really.
It's great.
interesting.
Yeah.
That's
It's like
really-
telling secrets at summer camp. Like
Yeah.
you just whatever secret you want to tell. Yeah.
It's like closed session. I can say.
It's great. Yeah. Yeah. Other questions or concerns or any questions about association materials or resources?
One of the things I would say is the amount of hours that these board members put in, and they don't get paid for this. Sometimes I feel guilty. when I-
Well, we don't get paid.
It's like,
Yeah,
I told you.
we forgot to tell you.
Oh,
So I appreciate the work that you guys do. And again, you get something paid for.
yeah.
But I get paid.
Me too. So it's like I'm in awe of all of you who are here like this late, engaged, asking questions. I think that you guys have an excellent school year in front of you. I wish you all the luck in the world. If anything comes up or if there are any problems in the spring, reach out. We're ready to help you. And if something as small as, is this addressed in policy? We are privileged to receive your questions, and it's an honor to be associated with your efforts.
Thanks for coming.
Yeah. I'm gonna get on the road because I have a bit of a drive in front of me back to Missoula. But as I said before, reach out and go forth and do no wrong. Yeah.
Motion to adjourn.
Safe travel.
Second. All those in favor? Meeting adjourned.
Wonderful.
Yeah.
That's okay, we'll end.